Actually, there are assets that don't belong in your trust. One of the assets that we usually counsel people not to put in the trust is their retirement accounts. And you may say, well, wait a minute, I've got $1 million sitting in my 401k account that I've accumulated over 40 years of work history. Well, why wouldn't I want that in the trust? You can put it in the trust and have it managed if the trust is drafted properly, but generally, your 401k accounts or your IRA accounts are qualified accounts, meaning they accumulate on a tax-deferred basis. They're tax qualified. And all of those accounts have what we call independent beneficiary designations. And you can do a lot with properly drafted beneficiary designations. So in the case of a 401k or an IRA, generally, you're going to want your spouse to be the primary beneficiary, and then you want your kids to be the secondary beneficiaries. And the reason is, if you pass away, everything rolls down to your wife. When your wife passes away, everything then rolls down to your children. The good part about doing it that way is, because it's a qualified account, if your kids are, let's say you've got 2 kids, each of them will get 50% of that $1 million IRA or $1 million 401k. During their lifetime, they can continue to let that account accumulate on a tax-deferred basis. If it's drafted so that it pays out to your estate, you've immediately accelerated all of the taxes. So from a tax standpoint, usually it's more efficient to let your kids draw it out over their lifetime. And what's really a shame is before 2020, a non-spouse beneficiary, children, could take their parents' qualified account and stretch it out over their lifetime. In fact, I had a case where a 7-year-old girl inherited her father's 401k. He passed away early, he had leukemia, was divorced, so his 401k went to his 7-year-old daughter. So at that point, she was required to take the required minimum distribution based on her life expectancy of a 7-year-old. So it was a very small amount. And that account continued to accumulate on a tax-deferred basis, so that by the time she was 18, there was a boatload of money there to pay for her college education. Now, the law changed in 2020 because of the horrendous federal tax situation that we're in and the national debt that we've got. Congress did act to change the law to say, okay, if a non-spouse beneficiary inherits IRA or 401k from 2020 going forward, that non-spouse beneficiary has to take that account within 10 years. And they did that so they could accelerate the taxes that would otherwise be paid. So now, unfortunately, if your kids inherit your IRA or your 401k, they can wait and let it accumulate on a tax-deferred basis for 10 years, but then in year 10, they have to take the full account and pay the tax burden that goes along with it. They can take, 10% a year. They can take, whatever they want in any year, but the bottom line is, at the end of 10 years, that account has to be taken. So when you ask what belongs in a trust and what doesn't, the 401ks and the IRAs, the tax qualified accounts, are usually the accounts that we counsel on not putting in the box. Well, and a lot of people ask me, for instance, with their vehicles, should I put my vehicles in the trust? And normally I counsel people not to put their vehicles in the trust. There's a process through the DMV with a certified copy of the death certificate that you can transfer the title to cars very easily. You don't need to have them in the trust, even if they're, an expensive Mercedes. However, I had a client who had a 1967 Corvette that was valued at about $150,000. That belonged in the trust. So, if you have a classic car, or you've got if you're the kind of client that's got the Lamborghini or the Ferrari, we may want to title that in the trust if it's a $500,000 car to avoid that problem. But, generally cars are going to stay out of the trust. And I also counsel my clients with their ordinary checking account that they pay their household bills with. Normally people keep maybe, $5,000, $10,000, $15,000 in a checking account to pay household bills. You don't need to retitle that in the name of the trust and have a trust account to do that. However, I had a woman in Rancho Santa Fe who, when I went through this scenario with her, I said, what do you keep in your checking account? She said, well, I generally keep about $150,000 in my checking account. And I was like, first of all, why would you want to do that? You're not getting any interest on it. She said, well, she was from that generation that just liked to have that security. And he said, well, okay, in that instance, if you've got an account with $150,000, that probably should be in your trust. So we're going to need to address that. But generally speaking, your household checking account, your cars, those are items that'll stay outside of your trust.